Hello and welcome to Astranti's Law YouTube channel. Today we're going to be looking at some key legal terminology to help you understand a bit more when you're looking at your studies and you see these words that come up that seem a little bit complicated. So we're going to start off strong with ratio decidendi. So the ratio decidendi of a legal case is the Latin term for reason for deciding. We can work that out by thinking about the word ratio, and that sounds a lot like rationale. And then we also have this decidendi, which sounds a lot like deciding. So we can break that down into the reason for deciding. What that means is that in any legal case, there's a big, long judgment, and it goes on for pages and pages and pages. And the ratio decidendi is essentially the part of that judgment that is actually the reason that the decision was made. It's also the part of the judgment that is binding on future courts, so therefore it informs future decisions that are made by future courts. In different cases. Then we have the other end of a judgment, and that is the obiter dicta comments. These comments are comments that are made by judges in the judgment, but they are not binding on future courts, and they aren't necessarily related to the decision. What obiter dicta comments can do, though, is tell you where the law is possibly going to go in the future, and it can give guidance to other courts or to legal commentators and other people who are interested in the general direction of the law as to what's happening, and it can just give a bit more context to what the judge is thinking. So one example of obiter dicta in action comes from the case of R and How. So in R and How, the question was put to the court of whether duress could be used as a defence to murder. So duress, if you're not sure what that is essentially saying that you were in some way coerced to do something. Typically what happens is someone is threatened, or someone they love is threatened, and as a result they are told that if they do not do the certain thing that they're going to do, then something bad will happen to that person or to themselves. So duress is used as a defence in a lot of crimes. So the question that was put to the court in R and How was whether duress could be used as a defence to murder. And the court said that no, it couldn't be used as a defence to murder, and they had lots of reasons for that decision, so that's our ratio decidendi there. Duress can't be used as a defence to murder. However, the judges also said, obiter dicta, so this is a comment that isn't related to the judgment, they said that they think it also couldn't be used as a defence to attempted murder. So we can't use duress as a defence to attempted murder. That was not binding on any future court, but when the issue did come up in a future case, people looked at how, and they decided that they would follow that obiter dicta comment and use it to make their decision. So it can form potential judgments in the future, but it's not a binding one. So that's ratio decidendi in obiter dicta. Now we're going to be thinking about stare decisis. So stare decisis is this principle that you need to stand by what has been decided. Again, this is a bit of Latin here, and essentially it just means that when we've made a decision in a legal case, we need to stand by that decision, which is how our legal precedent works in the UK. So we know that when a judge has made a decision, that decision is then used in future cases and we stand by it, unless, for example, you're the Supreme Court using the practice statement, but that's done very, very rarely. Another key term you might see a lot of in your legal studies is ultra vires. Typically this comes up when we're thinking about things like judicial review or delegated legislation. And what that tends to mean is when a government, for example, has been given a legislative power, so they're able to make a certain type of law, then sometimes they can operate outside of their powers. So ultra vires means outside of your powers. What that generally means is that they will have done something that is beyond what they were allowed to do. So in the case of delegated legislation, and we're looking at, let's say, a government, and let's say we're looking at a bylaw about a local park. So a government would be given the right, perhaps, to legislate about what happens in that particular park. And they might ban dogs from the park. That's okay. So they are legally allowed to do that under the act that gives them that right. However, they might then say, we're going to ban dogs in the park and also on the street outside of the park. If they have not been given permission to do that, to look at that street outside of the park, then they're acting ultra vires, which is outside of their powers. Similarly, sometimes it might be that it's an ultra vires act, but it's because of the procedures involved in making the law. So that might be, for example, your duty to consult before you make a law. If a government has for some reason not consulted with local people before they decide to make a law, then they are likely to be acting outside of their powers, which is ultra vires, and therefore they may face consequences for that. So we've looked at quite a lot of terminology so far, so we've got a couple more to look at, and we're going to be looking at criminal law as we move on. So in criminal law, we have two probably quite well-known concepts. If you've watched any sort of crime shows, this will come up a lot. So these are mens rea and actus reus. So the mens rea is the mental element of a crime. So that's typically your intent. Mens rea means guilty mind, and it forms the sort of intent of the person committing the crime. So if that's mens rea, we then have actus reus. Actus reus is the guilty act, so that's the act itself. So one way I like to think about this is, for example, I think about an offence. So let's say we're thinking about theft. Under the Theft Act of 1968, we know that theft is defined as appropriating property belonging to another with intent to permanently deprive them. So the actus reus of that offence would clearly be appropriating property belonging to another. So that's when you take someone's stuff or you in some way assume their rights over that property. And then we have intent to permanently deprive, and that is obviously our mens rea of our offence because it's got that word intent there, which is quite an easy way to spot it. It's not always quite that easy, but without both of those elements, you have not committed the offence of theft. So you'd need both of those to commit a crime. I hope you found this video really helpful for thinking about some key legal terminology. Let us know in the comments if there's anything else you want us to have a look at. We're really happy to do that. Thank you so much for watching.